Good morning. Hello, everyone, and thank you for attending today's webinar talking about your IP rights. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the question and answer widget at the bottom of your screen. We will try to answer these questions at the end of the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download it for future reference. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. Quick tip, if your screen freezes or you encounter other technical issues, pressing F5 will refresh the screen and fix most problems. If you continue to have technical problems, please send a note to the Q&A widget and our staff will assist you. This webinar is CLE accredited in California and Illinois for 1 hour of general CLE credit and in Missouri for 1.2 hours of general CLE credit. This CLE is also accredited or pending credit in Texas for 1 hour of general CLE credit. We award CLE credit based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement. We appreciate your participation in this webinar. My name is Robyn Ast-Gmoser, and I am a partner in the Thompson Coburn's Intellectual Property Group. Shown here are my partners and presenters today, Mike Nepple, Tony Blum, and Jon Musch. We are all partners specializing in intellectual property in our St. Louis office. Today we will be discussing how to use your trademarks, how to notify others of your patents, how to communicate with those infringing your IP, and statements related to litigation. First up is Mike Nepple to discuss advertising considerations.
Thanks, Robyn, and thanks everyone for joining us today. As Robyn said, I'm Mike Nepple. I'm going to talk to you a little bit today about advertising do's and don'ts, both with respect to advertising other IP protections that you may have, like trademarks or patents, and false advertising claims themselves. So first, let's talk about trademarks and patents. What I have in front of you now is a triangle schematic of how we generally look at trademarks on a continuum from unprotectable up until the strongest mark. The highest trademark protection is provided in terms that are coined. You see some examples there. Exxon is another example. These marks give you the strongest level of protection. The next notch down are the arbitrary marks. These are often, say, existing words used as a trademark. You can see Apple there. Now, whether Apple records would get a trademark today is a different question, but at the time those trademarks were secured, there wasn't a problem with Apple computers and Apple records obtaining trademarks. There's nothing about the word Apple that at the time that they were secured would make someone think, hey, that's a record company or that's a computer company. Your next two levels down are suggestive and descriptive. Where that exact line is drawn between suggestive and description is pretty much the Trademark Litigators Full Employment Act, but this pyramid gives you kind of a general idea of how we categorize marks. The struggle for startups or some of your clients or your company usually comes with the selection of the mark. There's essentially a natural tension between your salespeople and your marketing people on one side, and often the legal and the business people on the other. The salespeople just want a mark that's easier to sell, the product easier to sell, and it suggests the product that's being sold. This is often, though, falls in those suggestive and descriptive categories. So that's easier to sell, but that also risks settling into a niche of a weaker trademark protection down the road. On the other hand, if you coin a term or use an arbitrary term, that's going to take generally more advertising dollars and a more consistent effort to secure your trademark rights, but with that come a stronger mark. So there's a business decision there for you to make on is this a long-term for you, or is this something going to be only a couple of years? Now, There's also a overlay with respect to trademarks, and that's the public benefit associated with trademarks. With a mark, the public knows what it's getting when it pays its money. Most of the trademark law is essentially prefaced around preventing consumer confusion. And it's not just, the name or the types of goods that are eligible for your trademarks. Non-traditional trademarks are allowed, and in fact, it's been kind of an area of growth. There's something you might want to look for: identification or exploration by your company or your clients. Relatively recent examples: red soles on women's shoes have been granted trademark protection. Ink for fiberglass, tones for the NBC and the Intel themes. Those are all non-traditional trademarks, but they are trademarks. Once it's established in the public's mind, your company or your client company receives common law trademark protection. And like patent rights that we'll talk about later today, this includes the right to exclude competitors from using that mark. And those trademark rights are pretty powerful, even the common law rights. For the local attorneys here, most of you know that there's a Burger King restaurant in Illinois that is not the home of the Whopper. It's not the Burger King Whopper place. And it's allowed to use its trademark, Burger King, because it was first in. People in that area knew Burger King, not the Whopper restaurant, and it's still allowed to use that, even though the Burger King with the Whopper has a nationally registered trademark. So it has the power to exclude Burger King, based in Florida, from its area. Your next step is going to be with respect to PTO registration. So you're registering the mark with the Patent and Trademark Office. This provides you several benefits. Those benefits include essentially a presumption that you own the mark, nationwide notice of the mark to others, and it makes proving your damage claim, if you're the plaintiff, substantially easier. And for some of you who may deal with importation and the Customs and Border Protection, having a registered mark makes working to exclude products at the border much easier. Now, with respect to a trademark comes the responsibility to police that mark, make sure others aren't using that mark, and to make sure that you are doing your due diligence with respect to what's going on out there in the business world. So as part of that, your due diligence, you probably want to, on a yearly or 6-month basis, take a look at your mark portfolios and decide, hey, is the juice worth the squeeze here? Is the money we're spending to develop this mark still really worth it compared to what kind of protection we're getting out of using that mark? Turn a little bit now to advertising patent protection. Most advertising, I'll talk about a little bit later in my presentation here, really boils down to whether it's truthful or accurate. And you can advertise if it's truthful and accurate, non-misleading, whether a product is patented or patent pending. And sometimes, even though it's kind of counterintuitive, advertising a product as patent pending can provide you a little bit more protection than a patent mark. With a patent, your competitors can look up the patent and they know the exact and understand the exact scope of those claims, and they will often attempt to essentially design around your product. But with patent pending, particularly if your patent application hasn't even published yet, there's a little uncertainty on the scope of your claims. So your claims may give you a little broader and a little more pushback in the marketplace if you advertise patent pending. So that uncertainty certainly helps you. It certainly doesn't hurt you. So don't ignore considerations of advertising patent pending status. And the 1-year bar, as you see, there's an issue, and I want to make sure that you're on top of it. Generally in the United States, there's a 1-year bar for public disclosures. If you disclose something publicly, you can obtain a patent as long as you do so within a year. Now, that's pretty easy to do if you've got control of your inventors, but sometimes an advertisement may be considered an offer for sale. And if you've got an outside agency that's doing that, or an agency or entities that are presenting your products at trade shows, that may trip the trigger of that 1-year bar even earlier than you anticipate. So you need to stay on top of the issue of when was the first public disclosure through advertisement or at a trade show. Trade show is one of the things that trips some of the clients up on this. So make sure you're on top of that, the 1 year time period, so you don't forfeit potential trade protection. Moving on to general advertising law, there are a number of sources of laws and best practices, but at the end of the day, it generally turns on the same issue. Is the ad truthful, and is it non-deceptive? And the key to this analysis, and I'll talk about the Hertz case in just a second, but the key to that analysis is often what the consumer understanding of the message is. An ad can be 100% accurate and still be misleading because of how it's perceived by clients or by consumers. The usual way to enforce your advertising claims is through the Lanham Act, which provides for both injunctive and monetary relief. So the Hertz case is probably the easiest case. It's one of my favorite cases on talking about the difference between accurate and misleading. Hertz and Avis got into a dispute a few years ago. Hertz advertised that it had more new cars than Avis had cars. Avis sued, said, hey, that's not right. Hertz has 97,000 new cars. We've got 102,000 cars, so that's not true, so that's false and misleading. Hertz defended, and as we talked about, what does the consumer think? The consumer isn't concerned about who has more cars. The consumer is really concerned about who has more cars that I can rent. So that's what Hertz defended on. They said, look, Avis has several thousand cars that aren't available to rent, and when you take that out and you compare universes of rentable cars, our message is right. And the court understood that and accepted that. So you've got to look at it at the advertising message, both just on the plain words of the paper and how it's going to be understood by the consumer out there. Miller Coors, one offshoot that we're seeing with respect to advertising is the issue of actually targeting consumers about misunderstandings. This is an ongoing case, and it hasn't really been decided yet, but essentially what happened is AB sued Coors because of the message. AB created an advertising campaign saying Miller brewed some of his beers with corn syrup. That message about what the consumers received from the final product, it turns out corn syrup isn't in the final product. It's brewed out during the brewing process. But as part of Coors' argument, they've made the argument that, hey, it's brewed out so it doesn't get to the consumer. But they also accused AB of targeting consumers' misunderstanding of respect to corn syrup, because there's a lot of consumers out there that are concerned about high fructose corn syrup, and the corn syrup that's at issue with brewers is not high fructose corn syrup. And the court has certainly said interesting things about targeting consumers who have a misunderstanding or a concern about those terms. So comparative advertising can be a minefield. Do you really want to do this? I mean, you're really calling down the thunder if you're going after someone. If you're doing comparative advertising, you're generally the smaller company, and you can need to be sure, to be very sure that someone's going to go over your proof of what you're making and what claims you're making, and they're going to do that with gum-scraping level of review. Moving down, a couple small issues or one-off issues that we get often as keyword advertising. It used to be a substantial dispute about keyword advertising. Keyword advertising, for those that don't know, or a competitor picks out a keyword, pays a search engine to return or pop up an ad that when someone puts in that keyword. For example, I might be an independent mechanic. I purchased the keyword Ford. When someone puts in Ford repair, my ad pops up and it says I can repair Ford cars. That area of law has settled down in the last few years, and again, pretty much devolves into what's the communicated message? Does it confuse the consumer? You can return an ad that says we repair Ford cars, but you can't return an ad that says Ford implicitly authorizes us to work on their cars, or that we're part of the Ford network of approved mechanics. So again, what is the consumer takeaway from the message that you're looking at? So to sum up kind of my area of this talk, give you 2 points to look at. One is with advertisement you've got to look at both the express and the implied claim. The express claim is out there on the paper, but you got to look at the implied claim as well. And I would recommend sometimes if you're too involved in the creation of the advertising campaign, or perhaps you're the attorney who's signing off on it, you may get too close to that and not pick up the implied claims. Because those implied claims, those are sometimes difficult to tease out. And the second issue is kind of what we talked about with respect to advertising, trademarks, or patents, or whatever it may be. Those are all good and scalable. You can put money in when times are good, and it can be used both offensively and defensively. You can do a patent marking, securing your strong trademarks to exclude competitors, making sure that competitors are unsure of the scope of yours by advertising a patent pending, and that's scalable. And if times are tight, you can turn that spend back down and not concentrate so much on moving your marks from common law marks to registered marks or whatever it may be. So I think that's it for me today. I'll turn this over to Tony, who is going to talk to you a little bit about patent marking. Tony?
Thanks, Mike. All right, so patent marking. Your company, or you've gone through the process of getting a patent, and probably at the end, your attorney tells you should start marking. So the question is, what does that mean? How do you do it, and why is that important? So that's what we're going to talk about. And on the slide that you should see, this is an example of what patent marking is. You'll see this is a vintage channel lock pliers, I think from the 1940s. And on there, you'll see that there is stamped on the pliers is U.S. patents, and then a couple different patent numbers in the 2 millions. So this is what we mean by patent marking. By doing this, you're giving the public, you're giving your competitors notice that the product is covered by the patents that are stamped on the product. And why do you do this? Why does this matter? Well, the legal reason is pretty simple: money. If you don't mark, that's going to limit the damages you're able to recover in any kind of future lawsuit. If there's ever a need to bring a patent infringement lawsuit against a competitor or against somebody else in the industry. Under the Marking Statute, which is at 35 U.S.C. 287A, and paraphrasing that, if you don't mark, then your damages are going to be recovered or are going to be limited such that you're only able to recover damages after you've actually notified the potential infringer of the alleged infringement, or after you actually file a lawsuit in federal court. And this is important because, sometimes your competitor is selling a product that you can go buy at Walmart, and maybe you know about the infringement right away, and you can file suit. In those cases, marking may not be quite as important. But in a lot of cases, you may not find out about the infringement for a couple of years. Certain industries, products aren't publicly sold at Walmart. They are, smaller sales or more confidential sales. You may not know about it for a long time. And so you don't want to give up damages from that several-year period of time. You want to be able to recover as much in damages as possible. And I note that it seems pretty simple, mark your product and you can get more damages, but it becomes a little more complicated in the details. If you start to look around at products that you just use in your everyday life, you'll notice that some of them do have a patent marking on them, but a lot of them don't. And it may be because they're not protected by a patent, but quite often they are. It's just a lot of companies either don't mark or they don't mark correctly. And this is even the case with highly sophisticated, multi-billion-dollar corporations. Now, there are a couple exceptions to the marking rule that I'm talking about now. You only have to mark a product if it's actually covered by the patent. And in fact, you can only mark a product if it's covered by the patent. If you're falsely marking a product saying this is covered by patent and that's not true, that could cause some problems with false advertising or patent mismarking. And this comes up quite often because sometimes a company may, you may have a patent that is only going to cover some future potential product, or maybe it was a product that you thought the company was going to come out with, but then it was you decided to move in a different direction, and it was never commercialized, but that patent still cover one of your competitors' products. And in that case, you will be able to recover damages even prior to that, prior to filing suit or prior to notifying the alleged infringer. Under the Patent Act, in those cases, you're able to get damages going back, up to 6 years. The other exception is for method or process claims. Patents will quite often have patent claims that cover the actual product, the pair of pliers that I showed you earlier. But sometimes patents also have claims that are directed to a process. So it could be the process of making those pair of pliers, or just some type of process for making a chemical formula or using a computer. And you can't really mark a process. There's not something physical to mark. And in those cases, there is no requirement under the Patent Act to mark. Now, quite often, patents are going to have both types of claims. They might have patent claims directed at the pliers, and then another set of claims directed at the process of making those pliers. And in those cases, the best practice is going to be to go ahead and mark the product, to actually mark the product. A lot of times, plaintiffs' attorneys can be clever and try to get around the restriction on marking if the company failed to mark by only asserting the process claims. But that's not really the best practice, because quite often the product claim is going to be the stronger claim to sue on, so you don't want to necessarily give that up. And sometimes you may not know the process that a competitor uses, because it's going to be behind closed doors. It's going to be confidential, and so quite often it's just easier to be able to sue on the product claims. And so for those reasons, marking is important if you want to preserve your ability to get those past damages. So the next question then is, how do you mark? And the example with the pair of pliers I showed you before, that's the traditional way of marking. You basically need to put, and this is actually set forth in the Marking Statute at 287A, but you need to fix onto the product patent, or the abbreviation patent period, and then provide the patent number. Or if there are multiple patents, you can provide all of the different patents that are covered. But in around 2012, Congress actually provided a new way of marking, which has, I think, really become the preferred mechanism over the past decade. And that's, instead of setting forth all the different patents that cover the product, you can simply put patent period, and then you can put your website, so your company.com/patents. And this is really advantageous because, sometimes it can be pretty difficult to, if you have one patent, that may not be that difficult to stamp onto the product, but sometimes there are dozens or even hundreds of patents that cover a product. So that's easier to do on a website. In addition, the patent may actually issue after your product is already on the market. And if you've just put the website, then instead of having to go back and change the product or redo the molds, you can simply just go to the website and update the listing of patent numbers. Now I'm going to get a little more into detail about virtual marking in some later slides, so we'll get back to that. But I want to step back to where do you actually mark the product? And the best option always under the Patent Act is you want to mark the patented article itself. So here on the slides, there's an image of a graphing calculator, one that you may have used in high school or college. And if you flip to the back of the Texas Instruments graphing calculator, you'll see the patent marking with some patent numbers on the back of the graphing calculator. So that's really the best place to do the marking. Either, you can have, under more current situations, instead of putting the patent numbers, they could have done, patent period, texasinstruments.com/patents or something like that. But it's not always possible to mark the product itself. Sometimes there's just reasons, if you would actually put that text on the product, it may cause it not to work, or there's some other reasons why you're not able to actually stamp the text into the product. And in those cases, the Patent Act does provide alternatives. You're allowed to, in certain cases, for example, put the patent marking on a sticker and then put the sticker on the product. And then sometimes you're also allowed to mark the packaging instead of the product itself. But under the Patent Act, if it's reasonable to mark the product, then you have to do that. Sometimes a company may just not want to mark the product. They may instead want to mark the packaging. And, if their reason for doing so is just simply, we think it's easier to do, well, that may not be sufficient. And then in that case, you're not going to be able to get those damages for pre-notification. And it's not always a bright line or easy decision on whether it's reasonable to mark the product. Courts look at a number of different factors that are set forth on the current slide. Courts will look at the physical size of the product. Obviously, if it's a extremely tiny product where, if you would actually mark in text on the product, maybe nobody could even see it. In that case, it doesn't really make sense to mark the physical product. Courts will look at the cost of marking the product. They'll look at industry norms, whether the claim covers a single product or really a combination of multiple products. Courts will look at, whether the product already has textual marking. If you already have the name of your company and some other text on the product, well, it was probably reasonable to also add patent marking on it. And then courts will finally look at whether alternative forms of marking would provide adequate notice of the patent under the circumstances. But there's no single factor that's really determinative. Every case is going to, it's a fact question that's going to be different in every case. And quite often it's actually a question for the jury in a patent litigation lawsuit. On this slide, there's a image of a connector, a metal connector with a paper label around the center of it. And this is actually from a real case that was in the District of Arizona 8 or 10 years ago. And in that case, there is no patent marking on the connector or on that label. Instead, I believe the marking was on the packaging. And the patent owner argued, well, this connector is simply just too small. It wouldn't have been feasible to put the patent numbers on the product itself. And they moved for summary judgment, asking the court to find their marking of the packaging sufficient. And the court denied that motion for summary judgment and decided it was an issue for the jury. Now, the plaintiff here, the patent owner, ended up prevailing at trial. Infringement was found, but the jury awarded less damages than the plaintiff was requesting. The jury only awarded damages starting at the time that actual notice of infringement was alleged. So indirectly, the jury found that the marking was improper and not sufficient, and because of that, the plaintiff got less damages than it otherwise would have had it been marking properly. And in some cases, that may not be a big deal, but in other cases, you could be talking about millions or, in certain cases, even billions of dollars. Moving back to the virtual marking issue that we discussed earlier, it's not sufficient to, simply have the website on your product, and then when a user or when a member of the public goes to that website for it to simply just list, a couple patent numbers or, 5 or 10 patent numbers. Instead, the patent statute requires you to specifically associate products with the patents that cover those products. So often the kind of simplest way of doing that is going to have some kind of table on your website that's shown on the slide. Each row is a different product. In one column, you're going to have the product name. And usually you don't want to just have a textual description of the product. You're going to want to include the specific model numbers or serial numbers or whatever kind of numbers you have that associate the product. Sometimes there are multiple products or versions that have the same product name. So the more detail you can provide, the better. And then in the second column, you're just going to put all the different patent numbers that cover that particular product. And this usually works pretty well when you have just, a couple of products or, even 10s or 20 products. For certain, very large companies that have hundreds or thousands of products, this may become a little unwieldy. And in those cases, there's other ways to do it. Sometimes you may have a landing page where you have different categories of products, and then you can click on a category, and then that will take you to the specific products within that category and give you their patent numbers. Other cases, companies will actually have like a searchable database. You can type in the product name or the product number, and then it will, you hit search, and then it will pop up with all the different patents that are covered. The other important thing to note is that to comply with the marking statute, it's not sufficient to just mark 50% of your products or 20% of your products. You have to mark substantially all of them. And once you've started marking, that compliance has to remain substantially continuous and consistent. So if there's some period of time in which you stopped marking half of your products, well, that was not sufficient, and so the period of time in which you can collect damages is going to not start until you corrected the issue and once again are marking substantially all of your products. And to the extent you are licensing the product to other companies and they are practicing the patent, they also have to mark. If your licensee does not mark, then you're not in compliance with the marking statute, and to the extent you ever have to file a lawsuit, you're not going to be able to get those pre-notice damages. So that's usually something, and best practices would be that you contractually require the licensee to mark in the license agreement. This is the last slide on marking, just a couple best practices. Because as I discussed before, while it may not sound hard in theory, a lot of times marking, it doesn't get the highest priority. Companies are dealing with a lot of other fires that they have to put out, and so marking keeps getting put to the back of the queue. So it's important to put in place some type of procedures or plan for marking. That way, when each time you have a new product that's released to the market, you want to examine it to see if you need to mark, to see if it's covered by a patent. Each time your company gets a new patent, or even an old one expires, you're going to want to examine and see if you need to change the product or if you need to delete that patent number or add a new patent number to the virtual marking website. And it's also a good idea just to calendar kind of periodic reviews or updates, maybe on depending on the importance of litigation, on maybe a quarterly basis, just to make sure all your marking is still in compliance. And with respect to virtual marking, that's really the best practice these days. It's, I think, a lot easier than having to continuously change your molds or change your product every time a new patent comes out. It's pretty simple just to put that virtual marking on the product and then update the website whenever need be. But the important thing to do, though, is every time you do update the virtual marking website, you want to maintain the evidence. You want to maintain copies or archives of the website. If you file a lawsuit against your competitor, in 2020, alleging that they started infringing in 2018, it's not going to be sufficient for you to point to your website as of today and say, look, we mark. You have to show that you were marking back in 2018 when you allege the infringement began. So if you have those periodic archives of the website, that's going to really help. The other thing is, if you're in a particularly litigious industry, you might want to consider maintaining logs of all the different IP addresses that visit your marking site, just so you have that evidence in the future. And I note that certain sales-oriented companies have technologies so that when IP addresses that are associated with potential customers visit their website, that triggers some kind of alert within the company, and they can follow up to try to make a sale. Well, you might be able to implement the same type of technology for your marking site with respect to competitors. If you're able to figure out that one of your competitors is visiting your patent marking website, that would be really good evidence to have in any kind of future lawsuit. They were actually on notice of your patent, and maybe they continued to go ahead and infringe. You could use that in a lawsuit and potentially use that to prove willful patent infringement, which would entitle you not to just normal damages, but to enhanced or even treble damages. And also, if one of your competitors is visiting your marking website, that may just make you actually look at your competitors' products again and figure out whether there's any products out there that might be causing an issue or infringing your patent. So that's all I have on patent marking, so I'm going to turn it over to Jonathan.
Thanks, Tony. So I'll be talking about two things. One thing that folks on this CLE probably would consider a good thing, in other words, using your IP rights to reach out and try to protect your company and stop an alleged infringer, and something that you want to avoid, a declaratory judgment action. So to start with, you have a situation where you found someone who you believe is infringing on your intellectual property rights, and usually the first step on the process in terms of the interactions between the two companies is going to be a letter asking them or telling them to stop. But really there's a step that should happen before that letter goes out, and that's to develop a plan. More people have gotten involved in quagmires that cost a lot of money, a lot of corporate energy, a lot of time by leaping before they looked. So it's important to first develop a plan of who this target is, what this target is, what are they doing, what do you want to accomplish from reaching out and talking to that competitor, and then letting your battle strategy flow from the answers to those questions. And when you're reaching out to that potential infringer, there's a variety of different ways that can be done. I've identified a couple of different types of infringer letters on this slide, and they start out with what I've called the informational letter. This is the most benign of the set. It is simply reaching out and asking a competitor for information about their product. Now, that might have some sort of dubious or nefarious undertones to it, but at the end of the day, that's not a threat. That's just asking for information, and that's unlikely to be actionable on their side. The next step up from that is what I've termed the licensing letter. The licensing letter is, I have rights, and I think you should consider looking at those rights because you may need a license from me. That's obviously more hostile than simply asking for information, and as such is viewed by the courts as more hostile and will be, at the end of the day, more likely to be grounds for a declaratory judgment action. The next step up from that is your classic cease and desist letter. This is the one that everybody's familiar with, and is the I have rights and you need to stop because I'm going to, if you don't, I'm going to enforce them against you. This is the old cease and desist letter and very common. The most serious out of the bunch is the I've already sued you letter, which is obviously has hostile undertones because you usually attach the complaint with it, and you're basically saying, I have rights, I've sued you, let's talk. That one's obviously the most serious out of the bunch. But what kind of letter do you need? And really that should be guided by what you're trying to accomplish. Some folks, what they're trying to do is, as Tony was talking about, they're just trying to start the clock on damages. Say they didn't mark very well, but they want to get the knowledge out there to the competitor of patent infringement, that we think you, Mr. Competitor or Mrs. Competitor, you've got a product out there that's infringing on one of our patents. And in order to start that clock, you need to provide some basic information. And the basic information that's required is you have to identify the patent, you have to identify the product that you claim is infringing, and you have to identify who the owner is of that patent. If you don't provide that information, the clock doesn't start. Willfulness is also an important trigger. You're going to be, if you provide information of this sort and communicate that to a competitor, that's going to be direct knowledge that they will have of your rights, and can start the willfulness clock if they continue selling that product. Willfulness under the Patent Act in this instance can lead to things like enhanced damages and attorney's fees if the court deems the infringement to be exceptional. And I'll note that simple patent marking of what the kind that Tony was talking about, or generic knowledge of a patent isn't going to be sufficient for willfulness. I can't count the number of times that a plaintiff has claimed that my client had general knowledge in the industry of the existence of these products, and that because of that they were willfully infringing. That doesn't cut it. It has to be specific knowledge about the existence of a claim of the type that we're talking about in this slide. And what should, that plan that I was talking about at the beginning, what should that plan look like? Usually your knee-jerk reaction is not the right one. A lot of rights owners out there see a competitor and they lash out, want them to stop immediately because they're, taking food from my table. I've seen clients, climb over tables to get in the face of somebody who they thought was infringing their rights. That's not the right way to go. And you also need to think about how the communication is going to look in this age of social media. Everyone now is a producer of content, and everyone has the ability to snap a picture and post it to Instagram or Twitter or Facebook or Reddit or any of a gazillion other sites out there. And then you lose control of what was a private conversation, and make it very public. And maybe you want that, maybe you don't. And so it is important to go back and start thinking about those questions that I asked at the beginning. Who is the target? How will the target react? If the target is a large, sophisticated entity and you're approaching them about infringement, they get threats like that every day. They're not going to react harshly. They're unlikely to start posting things to Twitter. It's probably going to stay a private business-to-business conversation. If you're approaching somebody who's a much smaller infringer or a closely held company, then they may react very, very differently. How will the dispute be perceived publicly? A lot of this has to do with how you go about making the threat. Two examples that I can think of, both related to beer, amusingly enough. Some of the folks on this CLE may remember the Starbucks cease and desist letter that went out to a small microbrewery just outside of St. Louis about Frappuccino. They had this microbrewery had a beer that used Frappuccino or something like it in its name, and Starbucks wrote a cease and desist letter to them asking them to stop, and the brewery owner went out and put it on the internet, and it went viral, and they lost control of that dispute. Conversely, you can, there are ways to get positive press out of sending a cease and desist letter. A couple years back, Anheuser-Busch sent a cease and desist letter to another brewery, I think it was in Philadelphia, that was making a Dilly Dilly IPA, I think it was. And they sent out the cease and desist letter written on parchment, and it was delivered by a town crier because playing off of their advertising campaign. So you want to think about that. Finally, you should think about what the impact is of your communication to others. Is this going to impact my customers? And how is this going to impact my customers? And do I need to do something to ameliorate any impact if my competitor is also servicing my customers? So all of this is grounding down to the ultimate question of, I can tell them to stop, but should I? And am I prepared for what comes next? That statement presumes one thing that I want to touch on briefly. I'm not going to spend a ton of time on it. Is anti-patent troll regulations on cease and desist letters. A patent troll, many of you may have heard of, that's a pejorative term for an entity that goes out and basically they're a company that owns intellectual property and they assert that intellectual property against others to obtain licensing revenues, and that's all they do. While there are a variety of entities out there that would fall into that category if you look at it broadly, universities, for example, would they don't make the products usually, but they have from time to time asserted intellectual property against others. But there are also just as many out there that have will buy a patent and look for people to sue. And many states, because they don't, because of the bad press that's gotten around that activity, have put in place anti-patent troll legislation. And there are too many variations to go on here. I'm just going to briefly touch on the one key element, which is a bad faith assertion. And a bad faith assertion is usually one where somebody doesn't put in the effort. It's they haven't analyzed the product. They don't have any actionable theory of infringement, even if the creative claim construction. They make unreasonable demands either on turnaround time or money or the terms that they're seeking to license on. And all of those things are going to be looked at by a court to determine whether it's a bad faith assertion or not. Now turning to the thing that you don't want to have happen, declaratory judgment. A declaratory judgment is essentially the accused infringer that you've reached out to going straight to the courts and saying that there's a dispute here that I want you courts to resolve. About a decade ago, roughly, the line was fairly well drawn. Federal Circuit had a significant body of law out there, at least on the patent side of things, and it bled over into other flavors of IP. Here's the bright line. If you say these things, there's declaratory judgment jurisdiction. If you don't, there won't be. As much as the Federal Circuit likes bright line tests, the Supreme Court hates bright line tests. And in the Medimmune decision from about a decade ago, they basically obliterated whatever bright line there was. I've got the key issue here, but really it boils down to courts are going to take a look at what you say and what's the history of the interactions between you and the accused infringer, and determining whether that is sufficient, whether it's a sufficient threat, an immediate threat to warrant them dealing with a declaratory judgment action. Thanks to Medimmune, most cease and desist letters, if they have any teeth in them at all, are going to suffice for declaratory judgment jurisdiction. It's very hard these days to mount any kind of letter writing campaign without at least opening up the door to a DJ case. But the bigger question in a lot of instances is, does personal jurisdiction exist? If it's your home territory, sorry, you're probably out of luck. But if it's a foreign jurisdiction that you don't have a lot of enforcement activities in, you're probably going to be able to get out fairly quickly on a motion to dismiss. And that's because sending the cease and desist letter isn't enough to support personal jurisdiction. It's one contact, but the courts are going to look at how many contacts there are, and only contacts related to enforcing that particular IP is going to be sufficient. It's not going to be sufficient to have you do a bunch of business in that, selling a lot of product into that market. It's your enforcement activities in the IP. Real quickly, I'll touch on a couple of items. I've gotten some questions when we were preparing for this about whether there's any difference in the various flavors of IP, copyrights, patents, trademarks, those types of things. And the answer is no. There are a lot of cases out there that will cross-pollinate Many of these rules were developed in patent cases under the patent body of law, but they've been applied to other forms of IP just the same and with very little changes. Is there any difference between the states or between circuits? And the direct answer there is it's limited. There is some difference, but not much. A lot of that has to do with Medimmune and Medimmune setting the bar, and everyone else is following off of that decision. There's some variance in the wording and how courts approach it, but by and large, the tests are basically the same across the circuits. What's the impact of a trademark opposition? Now, for those of you who aren't familiar with the practice, if you have during the trademark prosecution process, there's an opportunity for concerned entities or entities that have an interest to oppose that trademark registration, say, I'm going to be hurt by that registration. Does that have any impact on declaratory judgment? And it seems like it should, because it's kind of litigation-like, and if I've been sued in one place, I'll be sued in another. But the courts haven't really bared it out that way. And that's in large part because a trademark opposition can be done for a variety of reasons that aren't just related to this is a different front on a one big war. You can do it for purposes of clearing out the registry of an old trademark or firming up the boundaries of the rights. How do IPRs impact declaratory judgment? IPRs have changed declaratory judgment practice, I think, a fair amount. But at the end of the day, really if you file a declaratory judgment and you assert invalidity, you can't file an IPR. So you need to think about, if you're on the opposite side of the coin and you're planning to file a declaratory judgment action, you need to think about what that impact is going to have on your litigation strategy. And finally, a couple of case studies. Merely owning an piece of IP isn't going to be sufficient for supporting declaratory judgment. Just because somebody has a patent out there, for example, that I want to get rid of, that's not grounds for filing a suit. Infringement letters alone also aren't sufficient to support declaratory judgment, at least not in a foreign jurisdiction. A rights dispute. This one's going to be really heavy on the history of the dispute. What have the parties been fighting about? If it's a dispute over the trademarks on jellies and you've got a new boxed cereal that you're coming out with, those two disputes aren't really that related, even though the parties are. And finally, negotiations over a license. What's been said is really going to be the critical piece here. If you approach it in a license negotiations in the vein of, I have rights, here's how you infringe, you need to accept my license terms, then that's very adversarial, and it looks like it, and it's going to look like it to a court. If you're just approaching it from a simple negotiation standpoint, that's less likely to support declaratory judgment jurisdiction. And with that, I will turn it over to Robyn.
Hi there. So it's Robyn Ast-Gmoser, and I will be addressing our last topic, which is statements in connection with litigations. So, of course, any company that's in the middle of a litigation needs to consider questions and consider carefully any statements about the litigation that's ongoing. And the discussion about those statements and what actions you take should include questions like, first, do we want to adopt a no comment policy, or do we want to say something? If you do want to say something, what is it that you actually want to say? What do you want to convey to the public? What do you want to convey to competitors? If you said what you want, how do you evaluate the impact on the litigation or to your company? And then finally, are there legal limits in place for what you can say about an ongoing litigation? And so first, we'll talk about what's going on in a litigation. So parties to a litigation are protected by something very aptly called the litigation privilege. And the litigation privilege protects you from tort claims like tortious interference, for statements made during a litigation that are, in the litigation by a party for the purpose of the litigation, and a statement that is related to a logical goal of the litigation. And so if a statement meets those factors, you are protected from a suit about those statements. A related privilege is called the Knorr-Pennington doctrine for antitrust claims. And the Knorr-Pennington immunity is a limited exception to antitrust liability for certain actions by individuals or groups, and when those groups are intending to influence government decision-making through either legislation, executive branch, or judicial branch. So antitrust is an area of the law that protects the right of companies to compete against each other. And so they want to stop statements that intend to impact the marketplace and the ability of parties to fairly compete. So when you act in good faith and you need to work with government decision-making bodies, you can be protected under the Knorr-Pennington doctrine. For that immunity to apply, the challenge statement cannot be a sham that merely is an attempt to cover up a competitor's ability to compete in the marketplace. And when someone thinks that your action to your statement to a government entity is a sham, you can have intense litigation over that topic. In the context of an IP, there are sometimes allegations that a complaint was filed not for the purpose of legitimately enforcing IP, but just to hold a threat over a competitor and just to be able to talk about the fact that you filed a complaint asserting that someone is stealing your IP or infringing on your patents. So, the best protection there for both the court statements and other statements made to government decision bodies is to ensure that what you're saying is accurate and truthful and that it goes to a legitimate purpose. So now looking to statements that might be outside of the litigation. These should be carefully considered. You should ask yourself those questions that we talked about before, because uncoordinated statements, incorrect statements, or worse, false statements about an ongoing litigation could leave your company open to counterclaims, again, about unfair competition or antitrust, and that, unfortunately, would shift the focus of the litigation from your competitor's product to your company and the reason that you are pursuing the litigation. And you don't want that. You'd rather keep it to the company that you're suing. You don't want to be talking to all your people about why they made certain statements. So when you're making a statement, you need to avoid statements that are inaccurate or incomplete, such that they could be considered false advertising or unfair competition or antitrust. And you also want to consider the manner of the announcements and where you place them on your website and how you're conveying it to the public, what type of emphasis you're giving. The best course of action will be to issue, if you've filed a litigation, is to issue a statement that a litigation is ongoing or that it hasn't started, identify the intellectual property at issue. You can link to a copy of the current complaint, and then to appoint specific people who will respond to any inquiries about ongoing litigation. That would be your best course of action. If you deviate from that, you need to think through carefully who's talking and make sure that all statements are coordinated. Looking now about a litigation that has been concluded. There are two ways that a litigation will conclude. first is settlement, and the second is through a court action. So when your case is resolved through settlement, the content of the settlement agreement is most likely going to drive how you can talk about the settlement of the case. And often parties often negotiate whether the confidential agreement contents are confidential, whether the contents are confidential. You may negotiate your actual press release. Sometimes that's negotiated within the settlement agreement. You can discuss, if a party is taking a license, you can discuss whether the patent or owner is allowed to disclose that there's a license. And I want to tie in what Tony mentioned earlier. Make sure that your licensee, if you do get one, is required under the settlement agreement to mark the product. Now, when you have a case that's settled through court action, you need to look to the court order when you're drafting statements, because you still have an obligation to make sure that your statements are accurate and not misleading. And again, it would still be best practice to designate specific individuals or departments to handle an inquiry, and just make sure that what is going out about litigations is legitimate, is true, and is not just covering up an intent to harm a competitor. So I think that is it for our main content, and we've run over, so we don't have any time for questions. Our contact information is shown below on this last slide, and of course all of our profiles are also on the website. And we thank you for participating in our webinar, and please complete and submit the survey located in the widget at the bottom of your screen. Have a good day.